Good afternoon or morning, as the case may be. I'm Ken Mann. I'm Managing Director at SC&H Capital in the Special Situations Investment Banking practice. It's been my privilege to work with ABI to develop and sponsor an outstanding series of 3 short but impactful conversations for you. Welcome to the first of those 3, Understanding Executory Contract Rejection, Damages, Valuation, and Strategy. Thanks for joining us. We've got quite a large crowd registered. I'm sure people are still clicking in right now. It comes as no surprise that we have a large crowd when you consider the well-known panelists that we've assembled here for you today. Their full bios will be shared in the chat, and really they need no introduction, but nonetheless, I will give very brief introductions of the experts and then let them jump in and get into the conversation. So first is Alan Boyko, a Senior Managing Director with FTI Consulting in Denver, where he specializes in delivering sustainable business strategies, revitalizing underperforming and distressed mining and mining services companies, and advising their stakeholders. Mr. Boyko has been involved in many matters that include complex financial modeling, which I think might prove useful today. Brian Shaw, a past ABI president, is a member of Cozen O'Connor in Chicago, where he focuses his practice on financial restructuring, bankruptcy, and other in and out of court distress solutions, along with the attendant litigation, representing parties in interest in proceedings throughout the country. We owe a special gratitude to our next panelist who stepped in just 24 hours ago to fill in for Judge Kevin Carey, who had to appear in court in Dallas today. The Honorable Mary F. Walrath is a U.S. bankruptcy judge for the District of Delaware in Wilmington, appointed in 1998. She served as chief bankruptcy judge from 2003 through 2008. Judge Walrath previously was an attorney at Clark Ladner, Fortenbaugh and Young in Philadelphia, and is a widely regarded speaker on all things bankruptcy. And now our moderator, who surely needs no introduction, Bill Rochelle, is ABI's editor-at-large based in New York. He joined ABI in 2015 and writes every day on developments in consumer and reorganization law, as you all know from your inboxes. For the prior 9 years, Mr. Rochelle was the bankruptcy columnist for Bloomberg News. Before turning to journalism, he practiced bankruptcy law for 35 years, including 17 as a partner in the New York office of Fulbright and Jaworski. Thank you all very much for participating today. Bill, the mic is yours.
Thank you very much, Ken. And let me in particular thank you for producing and sponsoring these 3 webinars, the first of which we're presenting right now. And as Ken said, this webinar deals with executory contracts. Depending upon how I look at it from day to day, executory contracts is either one of my favorite or least favorite topics. It's least favorite because it is extremely controversial. There is much that is not known or ever will be known about the law of executory contracts. We couldn't, if we wanted to, cover it comprehensively today because it's simply far too vast. What we are going to talk about with regard to executory contracts is, first off, what is an executory contract? Whether to reject a contract, when to reject a contract, or if you're selling and assuming a contract, how to compare bids. I think logically, we begin with the question of what exactly is an executory contract? Now, you would think that a term that is so integral to bankruptcy practice would be defined in the bankruptcy code, but lo and behold, it is not. To have a definition of contracts, we first had a marvelous definition given by Professor Vern Countryman of the Harvard Law School. This was back in the 1970s. And Professor Countryman came up with the idea that an executory contract is one which is so far unperformed on both sides that a breach by one would entitle the other not to perform. And this definition served well, not perfectly, but back in the year 2017, Professor Jay Westbrook from the University of Texas at Austin Law School came up with what I will call a competing definition of an executory contract. And the professor in Austin defines his, or calls his definition, a functional analysis. And frankly, depending upon what your case is, you may want to consult either with the Countryman definition or the Westbrook definition to figure out whether you are or are not an executory contract. This is an issue that I think is going to remain open forever. The Countryman analysis is gaining more traction. Indeed, within the last year, the Fifth Circuit in dicta said that the Westbrook analysis could be the proper analysis to observe in some situations. But that having been said, there are areas that are very much in doubt about whether or not it's even an executory contract that can be assumed, much less assigned. For instance, limited partnerships, surety bonds. Are they executory contracts or not? Law goes some ways, both ways on those topics. And then you have other contracts that seem to be executory, but maybe you can't assume them at all, such as liquor licenses, gaming licenses. And I'm wondering, panelists or judge, is this something that you often confront in your practice or on the bench, where you have something that's in front of you that may or may not be an executory contract? In other words, do we really have to worry about definitions, or is it always apparent that something is or is not assumable or rejectable?
I'll take a crack at that, Bill. It's interesting. When I was preparing for this, the fact that I had to go back and brush up on the Countryman and the Westbrook definition, even though I've been doing this for 30 years, probably indicates that neither are perfect, and that the issue's not litigated that often. And I think the Fifth Circuit may have even mentioned that. And I actually think that is part of the reason why this will stay open potentially forever as an open issue, is because more often than not, while you have to potentially explain whether the contract is executory when you're facing your client and you're explaining to it how to treat it in a sale or a plan, or if you're dealing with a lease in a short period of time after you file, take the lease out of it because that's an easy question. More often than not, when you're dealing with the sale or the assumption and assignment, practical business issues take over. And you rarely, and I can't actually recall ever in my career having an actual fight over whether the contract was executory or not, because any fight over the assumption and assignment usually came down to dollars and cents and a little bit of assurance that they were going to continue to get paid by the new guy. So that's kind of my practical feeling of the issue. Obviously, we have a judge on and other practitioners, but I don't think I've litigated that issue once in 30 years.
Judge Walrath, I'm curious. How do you see it from your side of the bench in terms of whether or not there is or is not a right to assume, let alone assign, a contract?
Well, I agree with Brian that it's rare that it's litigated, but it has been litigated, and sometimes it's because one side realizes that if it is an executory contract or not, they'll get all or nothing. I had it litigated in the Weinstein Company case a couple of times. It was an interesting issue where the producers and actors in a film that had been made were entitled to royalties going forward. And the question was whether or not there were still obligations other than the payment of money left to be performed that would make it still executory. I ended up deciding that it was not an executory contract because the producer and the actors had already finished everything they had to do. The film had been produced and was in distribution, and the only thing left was the payment of money by the debtor. But it was a close question. There were a lot of issues. I had to learn the film industry and what obligations remained. But again, it was a question of they were going to get all or nothing.
You know, I remember, Judge Rochelle, your opinion very well. It seemed like a raw deal for the party who lost, because the party who lost was owed a whole lot of money going long into the future, basically as royalties for this intellectual property. But good grief, you don't make law. That's not your job. You sat there and you read the law as defined by the Third Circuit, and that's what you came down with. I mean, there's no two ways about it. You nailed it. It was a raw deal, but you don't make law.
And I felt terrible because it was a fabulous film, Silver Linings Playbook. And I loved the producer. I loved the actors. I thought it was a great film. And as you say, they kind of got the short end of the stick because we all know they get paid a lot of money to make a film, but really it's the royalties. And once it goes into syndication and Netflix, that's where they make a lot of money. So
yeah, it's really,
tell you what,
it's hard to get
Go
over
ahead.
the fact that that is the right decision, but someone's getting something for free.
Yeah.
And they're going to get to continue to use it effectively for free going forward. It almost feels like, and you know, there's a limit to the equity, but an unexpected windfall for that party.
Yeah.
But I think
Let's
sometimes, at least when you get to that, right, being executory or not is a zero-sum game to a certain extent, right? So both parties, if there's any kind of dispute there, especially when you're talking with clients, trying to reach an amicable solution at the end of the day is always better than taking the 0 or 100 type risk in a lot of cases.
that's true.
Listen, let's move on to a different but a related question, because in Chapter 11 these days, well, we used to have reorganizations. Now we usually have sales. But with that understanding, if you are analyzing whether or when to assume, does it matter whether or not the case is headed toward an old-fashioned reorganization or toward a Section 363 sale? Does it matter which way you're going?
I'll start there first. I'd say it absolutely does matter which way you're going. On a reorganization, as an example, if you're working for the debtor and the debtor has certain what I'll call contracts or executory contracts, whether they be sales or purchasing contracts that are underwater or losing money, you know, from a reorganization perspective, you know, immediately you want to cut the bleed on those, right? You know, you're going to reorganize. You've already done your work up front leading into the Chapter 11. And this is one of the most powerful tools of Chapter 11 for a debtor to frankly turn around its fortunes, right? So in a reorganization, you're much more likely to look to reject underperforming or poor non-profitable contracts literally day one. Some you're going to try to look at perhaps, you know, renegotiating during the period during the Chapter 11 period with the threat to the other party of, well, I'm going to reject it if we can't reach a deal. And then kind of lastly at the end or near the end of the case as you're wrapping it up, any other ones that just couldn't get done, right? Or what are you going to do with those? So I think in a reorg, you already have your plan set and kind of ready to go as to here's how we're going to use all of the tools of the Chapter 11, not just to, you know, reorg the capital structure, but also the profitability of the business. Now, flipping to a 363 sale, it's a little different, right? When you know you're going into a bankruptcy sale, you're less apt to reject contracts that other bidders or potential buyers might want. Okay, so pick sales contracts as an example. You have a sales contract that perhaps the company today that's in Chapter 11 of the debtor cannot produce or sell profitably, right? But that doesn't mean that a third party who's coming in as a strategic doesn't want that sales contract and is willing to take it because they can actually still perform under it profitably through some other channel that they perhaps have, right? And you're loath to decide whether or not some of those contracts don't have, even though they might not have any value to you, they may have value to other parties. So you typically sit and wait, see how the 363 process plays out, because what might be garbage to you is sometimes treasure to other people.
Alan, I have a question for you and for Brian, because from my perspective, I've observed this. It seems to me that a buyer in a 363 has a little bit more negotiating power vis-a-vis counterparties. The debtor has a history with them, and maybe it's a bad history, but a buyer coming in, it seems like they're more able to negotiate amendments to the contracts to keep them. Am I right on that?
You're absolutely right on it.
Yeah,
Go ahead,
absolutely. Absolutely. And I agree with everything that Alan just said. I really look at it very simplistically as on a reorg, you're really looking at internal data points. But on a sale, you're looking both internally and externally at other people's data points and what they think about the asset. But traditionally, particularly with big contracts, debtors have done that when they've tried to assume as modified to get a little better economics. Otherwise, they have to reject it. But I am seeing more and more buyers take that role. And oftentimes it's interesting because it plays on some of the other questions that we may talk about today, because it results in a delayed process. You have the sale, you have the list, you have the sale approved, but then there's like a week or 10 days in which the buyer can negotiate whatever they can negotiate under the threat of then causing it to be rejected. So more and more often, particularly in the set of circumstances we had now, which first was the pandemic and now is inflation, that people didn't understandably plan for the pandemic, but they also don't seem to have planned for inflation. So people are negotiating terms.
Yeah. Well, listen, tell you what, let's move on logically to the next level of discussion. Let's assume that you have decided to assume and sell. And let's say that you have, blessedly, several offers. From the debtor's point of view, is the highest offer always the best offer?
Maybe that's
No.
Alan's question, because he's going to have to testify about highest and best.
Sure. I mean, I guess I'll think about it like this, right? So when we have competing bidders, right? Naturally, what we're trying to do in the auction or throughout the sale process is get each of the competing bidders on the same level, except for kind of what I'll call economics or cash dollars. Okay, so usually we try to true up, all right, these are the assets both of them want to buy. And then now part of that economics comes down to contract cures, right? What are they willing to assume and cover from a contract cure basis? And a lot of times you can calculate, or nearly always, you can calculate exactly what that contract cure is. They're going to pay for it in cash. That saves the debtor money. We sort of add that to the value of what their bid is. Okay. And so when we're looking at ultimately who is the highest and best bid relative to, say, the debtor as the seller, we're trying to make sure that we capture all the value of the economics first, right? And then some of the softer things afterwards in evaluating it, right?
Well, Alan, let me ask you this.
Mhm.
From the debtor's point of view or the creditor's point of view, do you want to credit dollar for dollar what the buyer will cure or what the damages in bankruptcy dollars would be to the estate if it were rejection.
Well, so on a cure bait, that's very, it's a
Brian
tough
has an
question.
opinion on that.
Here's what I'll say, and then other folks can jump in, right? I mean, dollar for dollar cures are relatively easy, right? Contract rejection damages from the debtor's perspective, I'm going to say typically just purely from the debtor side of the house, they kind of don't care, right? Because bankruptcy dollars are whatever it turns out to be, you know, sometimes it's 5 cents on the dollar, sometimes it's 25 cents on the dollar, right? And they're trying to, our goal is to naturally maximize recovery for all creditors, but it's what the highest dollar value coming into the estate is, right?
Yeah, no dollar for dollar credit unless it's 100% case.
Well,
Yeah.
let me counter that. From the committee's perspective, doesn't the committee want the buyer to take everything so that whatever's left is divided among fewer creditors' claims?
Absolutely. The issue is the buyer's payment, for example, of $100,000 cure claim really taking $100,000 out of the pot, or is it taking $10,000 out of the pot when it comes to ultimate distributions? So there's definitely the benefit. And yeah, the committee would like everything to be taken because unless it ends up that removes all their committee members, and then they got a different issue.
Mhm.
But the committee, of course, wants that. But in terms of evaluation on Alan's end, you got to have some idea what the ultimate return to creditors is, because it's rarely going to be 100 cents, and it
That's
will be
right.
some discounted number.
Right.
Well, Judge Walrath, I would love to put you on the spot with a difficult question. And that's this. Let's say you have just exactly the kind of a case we're talking about. You have the debtor advocating one buyer, the creditors committee opposing it, advocating someone else. Where do your sympathies lie as the judge?
My sympathies lie with the evidence. So if the debtor puts on Alan and he gives a financial analysis of whether this is in the best interest of all stakeholders versus the committee, and the committee often will put on evidence as well. I think that I don't automatically assume that what the debtor's advocating is the best for the estate. And I know there's some discussion about, well, it's the debtor's business judgment rule that applies. And if there's evidence on both sides, I think the court has to evaluate what is in the best interest of all stakeholders. So it comes down to evidence.
Well,
Judge,
there you have it.
May I ask a question of the judge? I'm just curious in those no, it's actually in those.
This is so rare.
Yeah, I know. I never get to do this. In those circumstances, does the makeup of the committee ever make a difference? Because I could see in a sales scenario where you've got a committee made up of trade creditors that need to continue to do business with the buyer as having more weight than strategic buyers or, for example, utility companies or somebody who is more, divested from the industry or the relationship. And they might have different motivations. And I was just wondering if the makeup makes a difference.
It does. And I've seen this specifically in the instance where there's an ad hoc note holders committee, and they're not going to continue to do business with the buyer.
Right.
So they just want cash, pure cash. And so you do often have that dynamic. And it's tough for the court to have to decide amongst those types of creditors.
Thanks.
Listen, tell you what, let's move on to a different topic. But first, we have a couple of questions from the audience. One dealing with surety bonds and whether or not they are executory contracts. That was the subject of a recent decision by the Fifth Circuit. And the Fifth Circuit held that a surety bond is not an executory contract. And in this particular case, the result of that holding was that the surety bond was not automatically assumed. The name of that case escapes me right now. I do recall it. My good friend Lewis Phillips argued on behalf of the debtor and the prevailing party. But if you go and look at my writings on Rochelle's Daily Wire and put in executory contract, you'll come up with it pretty quickly. But that is an example of a really difficult question regarding what is or is not an executory contract. But let me ask you all on a different subject. Let's assume that you're dealing with licenses or permits, and you've got to get court approval first, but it's going to be weeks, if not months, before the agency or whatever it is, or the third party, approves these licenses. How in the sandhill do you deal with that in a bankruptcy case where you've got to assume before you know whether it's really going to go through?
Okay. Why don't I start and then others can jump in? So at least on mining cases in the past, and I'll kind of touch on the surety discussion here too quickly. When we're selling a number of mines that have permits associated with them, a lot of times what we do is we try to ensure from the debtor's perspective that the buyer has lined up alternate surety bonds or has a deal in principle with the existing surety companies to replace the surety bonds that the company or the debtor currently has in place. Okay. And when we know the permits, mining permits, aren't going to be transferred for 6 to 9 months post-closing, what happens is we typically go to the states and the Office of Surface Mining and say, hey, this buyer is going to take these over. They effectively need an operating permit or permission to operate the mines post-closing when they close under the existing permits of the debtor until the permits are actually transferred. So what takes place is we usually lay out, hey, we're going to get this operating permit for closing. You're going to have 90 days to file all of the paperwork as a condition to close that says you filed all the paperwork to transfer the permits. And then we rely on the states to work through that processing of the permit transfers. And then once those are complete, 6 to 9 months down the road, usually not all together, but sort of one at a time, the surety bonds get relieved or released from the debtor and replaced with the new surety bonds that the purchaser had basically procured as a commitment to support those surety bonds once they get a hold of the permit.
By the way, I want to thank Brian because he reminded me that the Fifth Circuit case to which I alluded is called Falcon. And for any of you with executory contract problems, it's an erudite, superb decision. And it's the one that I mentioned earlier that alluded to how the Professor Westbrook's definition may be best applied in some circumstances. Well, let me ask you all a final question before we unfortunately have to end our discussion. Let's say you have an existing contract and your buyer or you would like to assume it, but it's just too cotton picking expensive. How do you deal with it? You want to have the best of both worlds. You want to have the contract, but you want to have a better price. How do you deal with it in Chapter 11?
I think Judge Walrath hit it before, and in trying economic times, you can even do it with a little more leverage, but you go ahead and say to the counterparty, the non-debtor counterparty, hey, I want to pick this up. I'd like to have a continued relationship with you, but I can't do it on these terms. So you need to make a business decision. This is what we can do it at. And you have a negotiation. And of course, this negotiation occurs in the midst of when the sale's also being negotiated, in the midst of when you're competing with other bidders who are probably having these same conversations with them. And it's a remarkably complicated thing. And it actually goes back to a few of the questions, like how does a court handle 400 assumption and assignment objections and cure amount issues at the same time during a 2-day sale hearing? And the short answer is it doesn't. Usually it gets dealt with after the fact, and that's where you realize that there really isn't necessarily that much change making going on in terms of the dollars of the bankruptcy estate. It's really an issue to the buyer. But it's tough. It's a tough situation. And anyway, I lost my train of thought, so I'm going to turn it back to Bill. But
Well, let me ask you another tough question, slightly related. How do you deal?
But Bill, you can amend. You amend and modify is the short answer.
Okay, so how do you deal with a counterparty, and this is before assumption, who is insisting on performance? How do you deal with that? How do you fend it off as you can?
Insisting on performance from the debtor?
Right.
You rely on more often than not, you rely on the code. And you delay and I'm speaking as a practical debtor attorney right now, and you try to dangle the carrot of prospective assumption and payment of the cure amount versus the stick, which is keep it up and I'm just going to reject you and you get nothing.
Yeah. Right. I mean, even when you're unsure on a post-petition basis and you're busy negotiating, sometimes you're delaying by maybe the debtor doesn't have the funds even in Chapter 11 to make the what I'll call the administrative post-petition payments to a particular party, right? So the trade-off with that counterparty is, yeah, okay, well, I can reject, yes, you're going to get 100-cent dollars or something close to that on your post-petition dollars, but all your pre-petition ones are gone. They're zero, right?
And I'm in the middle of a sale process, and if I'm rejecting your contract, no buyer's they're gonna start from scratch. You're gonna have nothing. So
that's right.
It is as you say, a carrot and a stick.
And the one other thing I'll say to this too is, with major contracts in those instances, you're gonna want to line up discussions between that executory counterparty and the buyers, right? Frankly, the debtor doesn't really want to be in the middle of it at all, right? Because while we can be the go-between or the mediator to a certain extent, you need them to work out their own deal separately, right? Not you working out a deal on behalf of a buyer.
And Bill, there was one question in the chat about how can you, decide what contracts are assumed and assigned after the sale. It's impossible to do it in these large cases before a sale. You can't be delaying the sale until every single counterparty has made a deal, or you've decided they're not going to make a deal and they have to be rejected. So this idea of designation rights for leases or working out negotiation of contracts that may or may not be assumed has developed. That has to be done after the sale is approved. It doesn't tell you exactly what the result is going to be for everybody, but you just can't hold up
That's what got me distracted before. You can't hold it up. You can't get it done in time. You'll never close. Plus, you'll give the unintended benefit of some crazy amount of leverage to one of these counterparties on the cure claim that they can effectively hold up the entire sale until they get paid in full.
Yeah.
Well, I must say, this demonstrates a couple of points that I think are interesting, if not unique, about bankruptcy law. Number one, the debtor who has none of the money has all of the leverage. And number two, this is an area, as described by Judge Walrath, where we have had a wonderful, marvelous development of bankruptcy common law. And I like to mention that as being very important, because there is such a tendency these days in some courts to say there's essentially no such thing as bankruptcy common law, that you have only the language of the statute from which you are required to derive all answers, no matter how difficult. And God bless Judge Walrath and others who do believe and frequently tell us that there indeed is bankruptcy common law, because I'm afraid without it, we simply would not have an efficiently functioning Chapter 11 bankruptcy system, which, as we all know, is the envy of the world.
Well, you might be giving the judges too much credit because most of the work is done by the professionals. They're the ones that cut the deals behind the scenes. And I've said it more than once. I never stand in the path of a settlement made by business people, because that's what bankruptcy is all about.
Yeah. Well, Judge Walrath, you said it very well. I'm afraid we have run over our allotted time. I invite all of you to join us again on August the 8th for our next program, which will be like this one, sponsored and produced by SC&H. So until August 8th, I thank you all for joining us. Be well, stay safe, and come back again on August the 8th. Good day to everyone.